said that you are an accidental lawyer. When did this accident start feeling like destiny?
Law and lawyers means persuading people, communicating with people. Everything else flows from the law. Whether you take commerce, you take construction, you take agriculture, you take the arts, you take science.
What is the difference between a lawyer who can persuade from a lawyer who's merely just prepared?
Persuasion versus preparation. There's no excuse for not being prepared. Every lawyer has to be prepared. Preparation, to my mind, is, and I've always been impressed by that quote of C.K. Daftari, time you take to think over a matter must be 3 times the time you take to read the matter.
Reading the room, reading the bench. How do you develop that? Is that instinctive or is that something that can come with practice?
But I think the best way is to put yourself in the position of the learned judge. So I mean, it's all very well putting up your own point of view across.
Correct.
That good drafting is an indication of clarity of thought. Gentleman J.R.D. Tata, he disliked long drafts. Always told his juniors, simplicity with brevity leads to clarity.
Cricket is such a strong passion that you've managed to sustain over so many years. And we did say that you were a cricket commentator.
Eventually, a good commentator analyzes, he dissects, he tells you why something that is happening, why is that happening. It's akin to counsel arguing in court and analyzing, let us say, a statute.
Judicial delay is one part which I don't know how to help, but it's something that I'm very keen to make some impact. I don't know how. How do we as a community band together to do something about it? Hello and welcome to the Daily Lawyer podcast. My name is Jenna Krishnan. I'm your host and the founder of the Daily Lawyer. And today is yet another episode in our Legacy series, which we bring to you in proud collaboration with Solomon and Company, which is a boutique full-service law firm based in Bombay, but has offices all over the world, has offices all over the country, and whose legacy spans 4 generations and across 115 years. The Legacy series is our shared mission, our shared vision to immortalize conversations with senior legal professionals who have contributed meaningfully to the Indian legal profession, so that all of us can maybe spend an hour in their company, dip into these conversations if we want some direction, some inspiration, or just spend an hour in the company of these people. With that, I'm so happy to introduce our next guest for this series and speaking to Senior Counsel, Mr. Fredun DeVitre. Thank you, sir, for being on the Daily Lawyer podcast and part of the Legacy series.
Thank you for having me.
Mr. DeVitre is a Senior Counsel of the Bombay High Court. He's also a columnist and a cricket commentator who's for 20 years commented on cricket on TV and has been writing about cricket for the last 40 years or even more. So I'm so excited to get into this conversation, and I'm not going to speak much. We want sir to speak about his life and his learnings in the law. So with that, sir, I did mention that rather I read an article of yours where you said that you are an accidental lawyer. When did this accident start feeling like destiny? When did, what drew you to the law and what is keeping you there?
Well, I don't know what you read, but maybe I'm not exactly an accidental lawyer, but I did drift into the law. Maybe I'm a drifter lawyer. When I finished my arts at St. Xavier's College way back in 1973, I frankly didn't quite know what to do. So in those days, most boys wanted to do business management, business administration. That was the in thing. So I said, Chalo, I'll also try my hand at that. And therefore I enrolled at Kalina, the university campus, to do my MA with economics and statistics. But frankly, statistics is not up my field. I felt quite going way over my head, etc. And I found that I was spending a lot of time playing table tennis.
Oh, okay.
So that my backhand improved a great deal, but not my economics or statistics. And I vividly remember how the change took place, because I was sort of a little lost as to what to do. And that's when I remember on an evening walk, my then fiancée, now my wife of 47 years, Zareen, she was doing her law at GLC, Government Law College, after having done a BCom and MCom at Sydenham. And she suggested that why don't you switch to the law? Why don't you come to the college? In those days, we had morning college because I had to do the October batch. And she said, as an incentive, that at least we'll meet every morning.
How sweet.
So I think that's how the whole idea of getting into the law started. But once there, I don't know, I took a fancy to the law. I found it quite fascinating because I think you realize, the realization dawns on you that law and lawyers means persuading people, communicating with people.
Yeah.
And, I've always, in college, in school, you had those exams or these courses which said, what you cut out for.
Yeah.
And they always said either journalism or law.
Okay.
And so I said, maybe one is destined to be a sort of a lawyer. And what fascinated you from the early days is that, just the sheer breadth and width of the subjects one was dealing with when doing law. And when you look at it, we tend to forget. Law seems to be the foundation. Everything else flows from the law. Whether you take commerce, you take construction, you take agriculture, you take the arts, you take science, anything, any institutional thing, you have to ultimately take recourse to the law. And I found that maybe I wanted to be a cog, maybe a very small cog in this whole judicial sort of structure of the country. And that's, I think, what fascinated me and got me into the law. Because when you consider it, I mean, I know I'm talking basics, but when you think of it, consider a situation where you don't have law. You go back to the old bad days of the Wild West with shootouts.
Invite the jungle to town.
Exactly.
Yeah.
So I found that law permeated everything. It was a sort of basic thing.
Correct.
And I found that quite fascinating, and therefore maybe stuck to the law and haven't done too badly, I hope.
Of course not. You're on the legacy series. So I don't know why you sir, actually asked me why me. And I'm sure at the end of this conversation, no one's going to be asking why me. But as a counsel, you have dealt with so many cases and you've had a long career so far in the profession. What have been some of the most impactful ones?
It's difficult really to choose one or two, but I think maybe the most impactful looking back was probably my first case.
Yes.
And it was a case way back in 1978, I believe, 78, 79, when I was just out of college. I just joined the bar, not even a year out of college. I joined the Solicitors firm and was working there just to gain a little experience. And that firm dealt with a lot of state government and state government bodies matters. It was the time when I think a few years after the then Advocate General H.M. Sirvai had been virtually forced out of office for a series of circumstances. And we were doing government work and we were handling a sugar price fixation matter for private sugar factories. Right. So there were 9 sugar factories and 7 years in which the prices had to be fixed. And so it was like dealing with 63 long causes because each year, each factory, different evidence, etc. It was an evidence matter, cross-examination. We had outstanding counsel. On the other side, we had Fali Nariman, who was outstanding, Anil Diwan, Andyaru Jinang, Gulam Bahanbati. We had, as our counsel, Mahendra Shah, Rafiq Dada, and when the matter went to court, Kapil Cooper, J.C. Butt, all giants in the field. And I was just out of college, a raw junior, and was thrown in virtually at the deep end. But what I found and what I learned from that experience was the fact that you can fight as much as you want to while you're in court.
Yeah.
Because Fali Yanker would sort of, obviously do the best for his client. And Mahindra Bhai was also a very vociferous advocate. And what I found was that no matter how vehemently they sometimes went for each other also. When it was lunchtime, there used to be a Maharashtra Sugar office on the third floor of the same building in which the arbitration tribunal sat. And Fali would sort of turn to Mahendra and say, "Come on, Mahendra, we have to go up for lunch." And today, there were three very eminent solicitor firms on the other side. And I was sort of virtually alone handling three senior partners from Mullah
what an
and Mullah.
experience, but
Absolutely. Mullah and Mullah, Daftari Ferreira, dear old Dandekar, we used to call him Firozka, and Kanga and Company. And Kanga and Company had some arrangement whereby they would send lunch every day. And we would all sit and have lunch together, no matter how fierce the fight was. And very interestingly, I was recently reading a judgment of the Supreme Court in which a bench of three judges, two of them decided one way, and the third judge decided to dissent and decided. So Justice Rishikesh Roy, who was the head of the principal judge, I mean
on the bench,
senior most judge on the bench, put in a afterword to the judgment, and I found that very fascinating. And he said, we've dissented. My brother judge doesn't agree with what we say, but that is the essence of the law. And in that context, he quoted Shakespeare in The Taming of the Shrew. And I found the words ringing a bell, because what he said was that Shakespeare said in Taming of the Shrew, "And do as adversaries do in law, strive mightily, but eat and drink as friends." And that's exactly what I learned in this one particular matter. And then, of course, there were many, many others. But there was, for example, the PIL in regard to the indiscriminate hoardings in Bombay, which was sort of in Mumbai, which was disfiguring many old buildings. And so there was a PI, Miki Chagla was leading us. And that was another very big learning experience. And there were many strong orders passed. But I think over the passage of time, I think people seem to have gotten many of those orders because this problem still seem to persist today in the city. So, I mean, there are too many to recount in that sense.
It's not actually really fair to ask this question also, I feel, because, there are so many that's difficult to pick. But what lovely experience learning at the feet of greats like that. One of the things that I also learned first in a solicitor's firm, and they would say the junior most should know the brief the best. That was the job. And so preparedness is something that we were taught. But you mentioned persuasion as when you were talking earlier, and you said as one of the hallmarks of a lawyer that you're able to persuade the court or anybody else. One thing, when we would sit on the advocate's table and the counsel is on his legs arguing, we may be prepared, but I don't think we ever learned. I should speak for myself. This difference between preparedness and persuasion, that used to really come out very clearly when you were sitting there and somebody's arguing. What do you think is the difference? What is the difference between a lawyer who can persuade from a lawyer who's merely just prepared?
Persuasion versus preparation. I don't see why a lawyer who's well prepared
cannot
be persuaded. I mean, you're speaking in terms of a binary, and I don't think that's necessarily true. Because preparation. There's no excuse for not being prepared. Every lawyer has to be prepared.
What does preparation mean?
The preparation, to my mind, is not just reading the brief. Preparation, to my mind, is thinking about a matter, and thinking a lot about the matter. I read and I've always been impressed by that quote of C.K. Daftari, another great advocate, who always said that the time you take to think over a matter must be 3 times the time you take to read the matter. So thinking of the broader aspects of the matter, sometimes you're on a walk, sometimes you're, post dinner siesta or whatever. And thinking about a matter is very much a part of preparation. But a persuasive lawyer, I think, has one great advantage in the sense that he can read the mind of a judge and anticipate questions which are likely to arise or which the judge is likely to be having a doubt about, so that he can clarify. And he's a little more focused then some well-prepared lawyers who, because they are so well-prepared, sort of, and have read everything, can sometimes be a little meandering. I mean, I'm not talking generally, but you do find sometimes that the more you prepare, the more you think you should be communicating.
All of these
Whereas
things.
I think the persuasive lawyer is a little more persuasive. But as I said, I don't think that the two are in compartmentalizers.
Correct.
Persuasive lawyer can also be well prepared, has to be well prepared, and a well prepared lawyer can also be very persuasive.
Yeah.
So
then how to develop that? Like, understanding, reading the room, reading the bench. How do you develop that? Is that instinctive, or is that something that can come with practice?
But in my experience, the person who read the bench the most, I mean, each one has their own individual, was Mr. Narima. Mr. Call him Fali Uncle because he was a family friend. But the manner in which he was arguing almost as if the judge was going to ask him the next question. It was I don't know, maybe it's instinctive, maybe it's just great observation, because law is observation. But it's very difficult to say how you can read.
Yeah.
I know there are mentalists who can read your mind, but I don't think lawyers are.
No, but how do you,
mentalists.
like, if there are lawyers or litigating lawyers watching, and if they have to, like, take a couple of tips, and how do you develop that? Because you don't have the opportunity to learn from those people, right? They are not there.
I think the best way is to put yourself in the position of the learned judge. I mean, if you were hearing the case, what would be impartial, be sort of objective? What would you think are the factors against you, which you might have to explain, which the learned judge might want you to explain? So, I mean, it's all very well putting your own point of view across.
Correct.
But sometimes you also have to deal with something which you know may be against you, and deal with that, because you know that the next question from the judge will be, but what about this? So I suppose it comes with experience.
Yeah, true. One of the things that, as a counsel, you have to argue whichever side you have taken the brief from. Have you ever had a situation where some positions that you have to take have gone against your personal convictions?
I'm surprised you asked this question, because it's only a recent experience where I was persuaded to accept a brief. Well, not persuaded, I accepted the brief to represent the government of a state which is very well known for its natural beauty and its flora and fauna, etc. And the dilemma was that if I were to succeed, then part of that natural beauty might well have been depleted.
Oh dear.
So, for a moment, you do wonder, whether you are doing the right thing. But having accepted the brief, I think there is no question that you have to do the best for whatever is your plan. I mean, you have to then put aside your personal convictions or whatever, and whatever qualms you have about this must be put aside, and you have to then argue the matter in the best possible way, as you would do for any client. Once you've accepted the brief, if you have that conviction that this may result, then don't accept the brief. But once you have accepted a brief, I think you are duty bound then to do the best that you can. In some cases, it can be beneficial if you can persuade your client, which may be a government, which may be anybody else, to see if there can be a middle of the road path.
Yeah.
So that things can be worked out. But that work sometimes is successful, sometimes is not. Sometimes it all depends on the person's handling the whole thing. But it was quite an experience to initially sort of question yourself as to whether you were doing the right thing, and then once you satisfy yourself that yes, I'm going to do my best, I think then the dilemma vanishes.
This is one of the problems that people highlight when it comes to lawyers. They say, how can you in good conscience defend? For example, when our 26/7 bomb blasts happened, that time, or Kasab's thing, the 26/11, the Kasab's thing, so many people said, how can they defend Kasab, who has in front of everybody like shot down people? So I think this is one thing which, I mean, you spoke about it, but if you can just sort of underscore that.
Well, I don't know. I mean, you're raising a very basic philosophical question. which is that every man is entitled to the best defense that he can get, however heinous may be his crime. And that is the rule of law. That is the manner in which society functions. And if you have a civilized society, that is so. Passions can run very high, emotions run over, but eventually the law has to take its course, and the manner in which it takes its course is you can't deviate from your normal rule because of the heinous. Fortunately, for myself, speaking for myself, I have never ventured into aspects of criminal law, but I can well imagine that there are occasions when people dealing with criminal law
will have these kind of
would have
quandaries.
these sort of dilemmas. And, in civil law, it's much less.
Easier.
Than,
Less. You're right. We have to shift gears now a little bit because we can't, if anyone looks at this office, they know that your cricket is such a strong passion that you've managed to sustain over so many years. So, and we did say that you were a cricket commentator, you were a columnist for cricket. So how did
Actually, I don't know whether to take it as a compliment or not, because that was about 25 years ago and people still talk about it. So that suggests as if nothing of significance has happened in the last
dear. So we'll talk, but how did you manage to sustain this passion for cricket given a really busy career with the law? And, just talk to us a little bit about how that is fed into your profession as well, if it has in any way. How did you manage these twin?
I think if you have a passion for something, I think you make the time for it. And, you're almost suggesting as if, did your legal training come into your commentary, or did your commentary come into
were there any
training kind of
things that go up
no,
and down?
I trying to recall the details of it. I recall an incident when we were doing a commentary maybe in the 1980s at the Wankhede Stadium, and Tiger Pataudi, with whom I did a lot of commentary, he was the expert. In those days, he was an expert. And West Indies were touring, and Desmond Haynes was a West Indian opener, very famous. Greenwich and Haynes were perhaps one of the great opening pairs. And Desmond Haynes was given out for what was known as handling the ball. In other words, he had played a shot, the ball was trickling towards the stumps, and he wanted to push it away. Now, what he did was that he pushed it away by shifting from his bat from the right hand to his left hand and pushing it away with the right hand, so that he wouldn't hit the stars. The Indians appealed. He was given out. It was a very rare occurrence. It was an uncommon sort of thing. We were all flummoxed in the commentary box. And I always carried the laws of cricket book with me. So I quickly turned to the relevant law and put it before Tiger Pataudi. So he read it out, and he sort of read it out as if this was second nature to us. And he explained the difference between the pushing away the ball with the bat or a hand holding the bat, which was permissible, and pushing the ball away with any part of your body not touching the bat. And, everybody was so applauded us and said, wow, these guys know their law. They didn't know the backstory, because 5 minutes earlier, none of us knew that this what the law was. Yeah. It was a very rare occurrence. It was, I think, only the 4th time in cricket history that this had happened. But like a good junior handing over a particular case to a senior, you sort of you handed over something to the expert, and he read it out. And that was a marriage of law and commentary, and a very
amazing.
In a very,
and do you have any example for the reverse?
Of
like you've been, you've been commenting. Any experience of your commentary that you were able to take into your legal training or into your advocacy or something like that?
I really don't think that.
No?
I can't think of anything major in that. But there was one very amusing incident where we were again doing the commentary here in Mumbai. Actually, being a lawyer and doing commentary, you meet many of the players. And some of the players who came from abroad were also lawyers. For example, Martin Snedden, he was a fast bowler who bowled with Richard Hadley for New Zealand. We were in Bangalore doing the commentary, and in those days there used to be a rest day after the 3rd day generally. And we were friendly. So Martin said, why can't I come and see one of your courts? So I took him over to the Karnataka High Court on the rest day. And he was fascinated with our whole system. Of course, he couldn't get over the fact of the sheer number of black coats and black gowns that he saw in the corridors and the courts. But it was quite an interesting experience to have an exchange of views with a cricketer lawyer.
But was he practicing or he was?
He was. There was Alan Crompton from Australia, who was the manager with Bobby Simpson, I think, and they came. He was also a lawyer. Interesting to sort of talk with them. But the amusing incident that I was going to tell you about, was just trying to recollect it in some detail, was when we were at Bankade and we were doing a commentary with Tiger Pataudi and a number of others and Salim Durrani. Now, Salim, I think, was doing the Hindi language commentary. He was very, very nice person. I mean, a genuine, good human being, to the point of sometimes being naive, very simple. And he had this peculiar habit of calling Roger Binney, who's now, of course, the president of the BCCI, in those days was an outstanding all-rounder for India. He used to call him Rogers Binney. Now, as everybody knows, there used to be a very famous drink manufactured by a Parsi company called Rogers, and it was very well known for its soda and its raspberry and the Parsi functions that it served. So, and a satirist wrote an article that morning in a newspaper saying that Mrs. Binney is going to sue Salim Durrani because he has added a new fizz in her life and it's for defamation because he can't get her husband's name right, etc. Now, Pataudi could be a little mischievous, so he mercilessly teased Salim, saying that, oh, you will be taken to court, you will have to pay a lot of damages, and it will ruin you, etc., etc. And Salim was, I think, naive enough to believe that Pataudi had been his captain, naive enough to believe that Tiger was being serious about the whole thing. So he came to me and pleaded with me, and he said, he used to call me by my Parsi name, Fredun. And he said, Fredun, please, you have to save me. You are a lawyer. You please come with me to court, this, that, and the other. And of course, at the end of the whole day, we had a huge laugh about it. But it was again one of those things where commentary and law sort of came into, in an amusing way, but it did. And these things, I mean, when we were once in court before Justice Deshmukh, and he was some item 10 or 12 or I don't know, or 20 or 30 or something on the board. And I don't know, for some reason, the board collapsed that day. And, you know, when a board collapses, suddenly everything is adjourned and your item comes up when you don't expect it to, comes up much earlier than you expect it to. So we were not there when it was called out, and the judge was good enough to sort of keep it back or something of that sort. And when it did reach the second time, I sort of apologized and said, I'm sorry, but we didn't expect the board to collapse. And I'm not sure, but I think it was shortly after the test match in which India had collapsed. Maybe it was the test where India went all out for 42 in an innings. And I said, I'm sorry, but like the Indian cricket team, your board had collapsed. And Justice Deshmukh shot back saying, but it doesn't collapse as often as they do.
Oops. Yeah. But, coming back to court and appearing before court, we were speaking about this sometime before we started recording. And I know that now we are just going back into the profession. But actually, I'm curious also whether your cricketing commentary way of, putting everything in a very short way, in a very active way, has that affected, say, the way you draft?
No, I don't know about drafting. But in a manner of speaking, what you were doing as a commentator, as a radio commentator, you're presenting a picture to, say, a blind man, in the sense that the person is not there at the scene.
There's no visual input.
That's right. So you're really presenting an overall picture. In television, of course, the visual is the primary thing. Your voice is the complement to the visual, although it doesn't always happen that way. But in whatever you do in commentary, eventually a good commentator analyzes, he dissects, he tells you why something that is happening, Why is that happening? What is the cause of it?
Correct.
Why is the field setting in a particular way?
Yes.
Why is the ball swinging in a particular way? What is the effect of the weather condition on the ball? It brings in a lot of science, etc. So there is a lot of analysis which goes into cricket commentary. Now, when you think of it, it's akin to counsel arguing in court and analyzing, let us say, a statute. Why did the plaintiff act in a particular way? What are you doing? You're really analyzing. You're really dissecting the facts. So, in a manner of speaking, the two are akin to each other. But to put it another way, any good commentator, like say Sunil Gavaskar or Ravi Shastri or somebody like that, any good commentator, I'm sure would have made a great counsel.
Yeah, I mean, because you have to also think on your feet, right? Like how, the example that you gave earlier about giving Tiger Watauti. Yeah.
And remember, in those days, we didn't have the kind of facilities that you have today.
Yes.
In commentary, for example, you didn't have all these action replays and these close-ups. Many matches were done with cameras which were not the greatest equipment at that time. It was good for that time, but in comparison to today, it would be hugely outdated.
Yeah.
And even in the law, for example, you didn't have today's computers and stuff like that. If you had to change a draft, which was cyclostyle, you had to change the entire page or the entire section. Not like today, you can just go into Word and delete something and the whole. So they were different times, but they were very enjoyable. It was a happy marriage.
It was a happy marriage, and. Since we did speak about drafting, that is one area that I'm very keen to know your views, because like you were mentioning before we recorded, you are not known, but a lot of people know you to murder their drafts, including...
That's being unfair to me.
Or, okay, you can murder your own drafts, so it's okay. But what do you know, and in that article that I was mentioning of yours, you did speak about the importance of drafting. And you also mentioned that some time ago during COVID, you'd given a lecture to younger lawyers on how to draft. So, as someone who sort of advocates good drafting, what does good drafting really mean? Why is it important? And how do we get better at it?
I know that's a lot of questions.
Yeah, rolled into one.
But, I believe that good drafting is an indication of clarity of thought. That's fundamental. Because when you may have myriad thoughts in your mind, you're wondering how to put it across. You put it down on paper, and very often the brightest thing suddenly seems to be very mundane when you put it down on paper. So you formulate propositions and you put those propositions down on paper. It adds enormously to the clarity of your thought. And I find that a very useful exercise. I'm told by people who knew the great gentleman J.R.B. Tata, but people who worked very closely with him, he disliked long drafts.
Okay.
And very often he lived by a mantra when you went to him with a draft. And he always told his juniors or his interns or whoever, his mantra was simplicity with brevity leads to clarity. That was a one sentence phrase. And I find that very much applicable to a good draft. We tend to sometimes meander, we tend to sort of be, say much more than we really should.
Yeah.
So, to my mind, a young draftsman, I mean, this is not intended for people who have been there, but a person just starting out, a young draftsman, I mean, I think you follow a pattern and you say the maximum things in the minimum words. If you can say something in 100 words, you don't use 1,000 words. But if you follow a pattern, if you follow a sort of, you start with obviously the parties, we decide who are going to be the parties. You decide why they are being joined. A few sentences. So that is one sort of section that you have. You then start by narrating your facts in sequence, date-wise, as far as possible. And in that section, what I call the fact section, unless it's absolutely necessary, I don't think you should mix up your submissions. Otherwise, it reads like a hodgepodge. So you you set out the facts. If there's some explanation to be given for a particular fact or why you said something in correspondence, I can understand you adding a line or two. But very often I find that the facts and the submissions are all merged together.
So I just want to clarify that when you say the submissions over here, it means your case.
The inferences that you draw
Yeah.
from the facts.
What you want to say about that.
Which is the
Yeah.
next part
Yeah.
of it.
Yeah.
So you have the parties, you have the factual position, and then you have your submissions. Your submissions may be legal, your submissions may be factual based on the facts, etc. But that ought to be a sort of separate submission, because that is the core of your whole thing, dependent on the facts. That is what will ultimately sort of be the basis of the judgment, the submission that you make on the basis of those facts. And then your usual, whatever are the mandatory procedural requirements. In a writ petition you say, I have not gone to any other court, and there's no alternate remedy, etc., etc. And then your reliefs.
Yes.
And I find it very useful that after you've done your whole draft, if it's a plaint, or for that matter, even if it's a defense, you go back to the para after the parties and before the facts. And in one paragraph or maybe two, you summarize, you give a précis of what you're arguing. I would always suggest that you don't do it at the outset, because you never know how your draft will shape, because you start with a blank page and then you put it in a logical sequence. So after you finish the whole thing, then you go back and just give the judge or whoever is the recipient. For every judge, I mean, youngsters must remember that every judge would like to see a good draft. It's just sort of, I suppose it makes reading easy, understanding easy, gives clarity. And not only a judge, but any recipient of that document would welcome a good draft. And it's common sense.
Yes.
So a little attention to drafting. You have to do your research, for example, before you start your draft. Now, I mean, I understand it's all very well to say all this while we are sitting here. It may not be possible when an attorney or a client is sitting on your head and saying, I want the draft as if it was, I wanted it yesterday, or give it to me overnight. But I have often told attorneys that I'm sorry, just give me a little time. Let's put the draft together. And it has worked, rather than giving some sort of a slipshod thing and missing out something. Always better to do your research before you finalize your draft. Now, when it comes to, say, obviously the same principles that would not apply to a defense when you're drafting a written statement or a reply to an affidavit. And but there also, if you have set yourself a pattern, and what I prefer is that I like to set out the facts as I see them, or from the point of view of
the other
the
side,
defense of the client, in the outset, in a sort of beginning. And then it makes it much easier, because then when you're dealing with para-wise comments, which we normally do, you merely say that, look, I've already dealt with it in so and so para. So you've already set out your case, and therefore you have one section where you set out your positive case, and another section where you're repelling the other side. And so all I'm saying is that if you have a structure to your drafts, it helps a lot.
Yeah, that's true. How do you, sir, one of the things, that younger lawyers now, or even students who are going to be lawyers soon, now they all have AI tools. And it's just
AI tools.
Yeah, for drafting and it's just going to increase in terms of augmenting your work as a lawyer. In the world that we are going into, especially younger lawyers are going into, how important is, all of this? Because if a computer can do it for me, there's a pattern and a computer can learn it and it can do it for me. And if any young lawyer says, why do I have to learn all this? One device will do it for me. What would you say tell them?
That would be a wrong attitude. I mean, I'm not a great computer. I mean, I'm just about learning a lot of stuff, and these youngsters are fantastic at this. But for example, I mean, I find sometimes when you ask a young lawyer to do research on a particular subject for you, I don't want, if I say, can you look at the law under section, whatever, let's say section, the agency under Contract Act, on this particular subject, I get a list of 30 judgments because they are all judgments listed in some Google or wherever you looked at, or in, and I don't want that. I want somebody to apply his mind before he gives it to me, sort out the judgments, see what is the relevant part of the judgment, etc. So I don't think that that the human element of the can be dispensed with entirely. I mean, I understand that AI will be the future, and that we all have to catch up with AI in some form. But I think AI will have to be, in that sense,
Used as a tool.
Used as a productive tool,
Mm.
and not as a sort of oppressive. I mean, I don't want to read 100 judgments merely because they are there.
Right.
Somebody has to analyze them.
Yes.
You can ask AI to do it, to do a good job. But we've heard of cases, particularly in America, and I think also one or two in India, where lawyers have relied on judgments thrown up by AI and then found that these were all made up.
Yeah.
So, I mean, you have to be careful. You can't just, because it's really misleading the court.
Yes.
And you are really preaching an ethical rule. You have to then follow up with each judgment, read each judgment, make sure it's there, whether it's overruled, whether it's not overruled, etc. All these tools may perhaps help you in that. But eventually, I don't think that human endeavor can
stop.
Can be stopped.
And when it comes particularly to drafting, would you say that it's all and well for a tool to do it, but unless you know how to do it yourself, you will not be able to teach the tool.
The shape that you give it is ultimately what you want to put it. I mean, it's after you've said all the facts, how you present it is a very important thing. I mean, the AI tool will probably give you a cold, factual kind of this happened here, but that's not how you may want to present it. Ultimately.
Yes,
there has to be your touch to it.
Yeah, I think what you said before, that you have to think about your case 3 times before you sit down to write it, and that's the part that cannot be outsourced to AI. The actual writing, I don't know, maybe it does a better job than us many times. There's one, because we're still in this whole world of litigation, and I have been a litigant because I was an in-house counsel. So you are a litigant to the court system. And it's quite like there are times when you feel very, very helpless because of judicial delay is one part which I don't know how to help, but it's something that I'm very keen to do, make some impact. I don't know how. What would you say? What are the reasons now? It's becoming unconscionable to a point. Is it systemic? Is it cultural? Is it, what is it actually? What do you think is the cause of it? And how do we as a community band together to do something about it?
I don't know. This has been debated and dealt with in ad nauseum in a manner of speaking. But is it cultural? Is the solution to be found in a structural framework, or I don't know? Maybe it's a combination of various factors. And in terms of cultural or societal, I think 1 or 2 points may need emphasis. One, we do happen to be a very litigious society.
Yeah.
In a manner of speaking, that is a vote of confidence in your judicial system. People come to court at the drop of a hat. Why? Because in many cases, they believe that they will get the justice that they deserve from the court, which is a heartening thing. But I think the solution to that probably would be if we can have some kind of an authorized, authoritative, responsible, local forum where people can take their smaller disputes and don't have to clog courts with all this sort of stuff.
Like that panchayat system we had.
Sort of, maybe a slightly more urbanized panchayat system. I'm talking of an urban environment. So that then people don't, society matters, for example. Surely they can be sorted. I know we have society registrar, but they must be effective because that is where the local element sort of comes in. Because absent that, you will have people then going to what we would call extrajudicial remedies or whatever, which will be disastrous.
Yeah, you're bringing jungle to town.
So therefore, maybe some sort of a authorized forum for particular localities might be a solution to reduce people coming into court. I mean, what is existing, of course, is a different thing, but there can be a depletion in filings, etc. One other observation, since you asked, what is the cultural thing that adds to the burdens of the court? I find that as a society, many of us, and I'm not excluding myself, are not given an option between following or respecting the law and disobeying the law when you know you will not be caught, or when you're not going to be caught on. Many of us prefer the latter option. I take a simple, it's a simplistic example. You are at a red light, no cop around, none of those security cameras or whatever those video cameras, etc., etc. If you drive through, nobody will catch you. How many would voluntarily stop at the red light? I think many of them would just drive through. It's only illustrative. I mean, I remember when we were in a city in the western part of India, and we were driving with a friend. I was driving with a friend. And we stopped at a red light and there was no other activity. Nobody was coming. It was a crossroad of 3-4 roads. And people from behind were honking us and sort of telling us, why the hell don't you move ahead? I mean, why are you stopped? Now, I don't know, maybe a greater respect for the law would probably voluntarily. You don't have to be compelled every time. Maybe a voluntary respect for the law greater might result in fewer filings. I mean, I think you can imagine the number of cases that would drop if we voluntarily.
You're right. I mean, if we are a little more compliant, I think.
Right. And I don't know, structurally, when you say, look, we've all known that the government is the largest litigant. Appointments to judicial offices is a major concern, and prompt appointments. I mean, you have to anticipate vacancies and then appoint. But I believe it's not a mere game of numbers. You have to have judges or select judges who are capable of delivering, well, what I would say is quick justice, of course, but also correct justice. That capability is very important to have renewed or retain the faith in the system. Because sometimes in the quest for quick justice, you might come to an incorrect conclusion. Now, we've had judges in the past, and in fact, why in the past we have judges today who are extremely capable of delivering quick justice and correct justice. But, I mean, I suppose like lawyers and like everybody else, judges come from various backgrounds with different capabilities. So I think the endeavor in future at least must be, if you can, and this must be not merely at the level of the higher judiciary. I mean, the first point of contact for every citizen is, I would say, lower courts, but they are the non-constitutional courts. They are the magistrate, the district judge. That is where, I mean, you don't want to go to a court where you are told that, sorry, the judge is not presiding today, or for whatever reason, the vacancy is there. So it's not just the higher judiciary. It's, I think, the entire system, the entire hierarchy is there. And that is where I think government comes in. And government comes in, I think, also in one more aspect, in the context of, because it is, whether you like it or not, the largest litigation. If government is represented by the bureaucracy, could take more pro-citizen decisions, prompt decisions, and decide matters at their level, the need to come to court will I mean, be reduced to a great extent. I recall when we were in, I mean, it's again a very simple example that I give you, but when we were in college in St. Xavier's, around 1972, 73, there was a students' council, and the then principal, Father Mesquita, refused to let the council pass a particular resolution. I can't remember the details now. Mr. Chinoy, who was the president of the students' council, I'm sure would remember everything. But he refused to pass, saying that it's not part of your constitution. You cannot deal with this subject in a resolution of the council. There were all of agitation, strikes. Everybody gathered at the Oval Maidan, and slogans, stuff like that. My goodness. We formed a staff student committee. And I happened to be one of the 3 representatives of the students, along with Claude Alvarez, who's now in Goa, and the late Rajni Iyer, wonderful lawyer. And there were 3 staff members, including, I think, one of the Jesuit priests and 2 staff members. I frankly can't at the moment recall their names now, but very nice people. And we went for our first meeting with a great deal of trepidation, in the sense that we had a whole charter of demands and sort of, aggressive, and let's get this done and let's get that done and all that. And we were completely disarmed, because when we presented our charter of demands, these three staff members looked at us and said, "Is that all? We should be demanding far more. Why are you resting content with this? Now look at the approach.
Yes.
This was a problem-solving approach, and the approach was that if they are right in what they are demanding, give them more than what they want. So I think if at the level of bureaucracy, at the level of government, there is a change in mindset on how to solve problems, I think courts will have a reduced role in all this.
Those are actually very new points, huh? This question is asked quite often. I ask this question often because this is one pet peeve of mine. No one has given you these kind of answers. Of course, the point of reducing filing litigations is something that we have heard, but not the rest. I think those are new. I think I want to go back to one other, we discussed a whole lot about your role as a lawyer and your thoughts around the law. We also spoke about cricket because that is another twin passion. But there's one thing we learned about you is that you're actually very fond of gardening.
Oh dear.
And I am a serial plant killer, so I'm really not the right person. I'd be happy to just keep one plant alive. But what is, how did you get into this in an urban city like Bombay?
Frankly, I don't know where you learned this from, but I don't think it's entirely
in
correct.
that
Actually, my wife, Zareen, is the one with the green thorn.
Okay.
But I do love to potter around in the garden. And in that sense, we've been very blessed because in all the places we stay in Bandra, we have our own garden. And unlike my wife Zareen, who loves to grow flowers and plants, I prefer fruit-bearing trees.
Oh, okay.
Yeah, whether it's papaya, whether it's limbus, whether it's bimlis, which is my favorite, whether it's coconuts or jackfruit, custard apple. Any of bananas. We have really banana trees. We have our breakfast from a garden.
Wow.
I prefer that. And, as lawyers, you feel a sense of elation when you win a matter. Obviously, a hard-fought matter, you succeed. You do come out of court feeling a sense of elation. But I can honestly tell you that the ecstasy you feel when you see a plant, in my case, a fruit-bearing plant, actually grow and then yield fruits, I think nothing in the world compares to that.
Is it?
Yeah. And I think, therefore, you asked me what gardening has taught you. I don't think I'm gardening in a major way. It's just a little thing that you spend a little time on the weekend or whatever. I think two things. One is patience. Because no plant grows overnight. You have to keep patient. Sometimes it may result in a failure.
Of
for
course.
whatever reason, it doesn't catch on.
Yeah.
So you have to be patient. And some fruit-bearing trees may take years together to flower or to fruit. And the other is, I think, caring. Because you have to nurture the plant.
Yeah.
You have to look after it. You have to nurture it. So I think these are the twin things. I know it sounds a little philosophical or highfalutin, but I think patience and caring are what being in the garden and growing these plants.
And maybe not even knowing how it's going to turn up, right?
Absolutely.
Like you're committed to that thing, not knowing.
But the pleasure of seeing it grow and stabilizing is enormous. And you correspondingly you feel terrible when you see something die.
Yeah.
And particularly when you may have been negligent about it or you may not have cared for it as much, you sort of feel guilty, you blame yourself.
I only know that feeling because I'm a serial not even a money plant, which somebody came and told me that you cannot kill this plant, don't worry. That also died. I don't know how. So I think God only decided, patience to iske paas hai nahi, chhod do. I just have one last question to finish off this section of the podcast, which is, you've had a wonderful career. We learned so much more about what your career has been, your thoughts around the law. What would you say, if you have to leave a legacy, like an enduring legacy, what would your version of your legacy be?
Legacy?
Yeah, it's the legacy series, so I have to ask.
Honestly, I am too small a cog in the wheel of the whole, I
This.
don't know what, judicial wheel.
Yeah, but
To
everyone
think
needs
of
a
leaving
legacy.
a legacy, I wouldn't think in terms of a legacy for the world. I mean, I don't think I'm qualified to leave a legacy. But
Or
since
how
you're
do you want
asking,
people to remember you?
since you're asking,
Huh.
at 73, I think it's fair for me to say that the legacy may still be coming. The best years may still be ahead.
Nice. And how do you want people to remember you? Yeah, legacy is like a very high,
in
like
whatever way they have been touched by whatever I have done. I mean, I don't know. I haven't frankly given it any thought in that sense. I'll leave it at that.
Yeah. Yeah, I know, but legacy is like a very heavy sounding word.
Absolutely.
So I understand why. But then it's a legacy series, so I have to ask you that. Anyway, we finished like the main part of the podcast. The last part of the podcast, something I do for myself. Because I do it for myself.
Okay.
Because I love hearing the answers. So these are typically shorter answers. It's called 5, 4, 3, 2, 1. So I ask you 5 of something, 4 of something, 3 of something. These are.
I don't think you can ever expect a lawyer to be short.
I know, yeah. See, am I short? I go all over the place. But shorter than before. So are you ready?
Sorry?
Are you ready?
All right.
So the first is 5 productivity tips.
5 what?
Productivity tips.
Terms.
No, productivity tips.
Okay. Productivity tips.
Tips. Yeah, like if you're giving tips on how to become more productive.
On a daily basis kind of
Yeah, in your life.
5 of them.
Yeah, 5.
I think one would be some form of physical exercise.
Achha.
Something. Maybe a form of yoga, basic yoga, just freehand movements, anything. There must be some form of physical exercise on a daily basis. What would the other be? The other would be, I think, some form of prayer. Speaking for myself, I find chanting my Parsi Zoroastrian prayers to be a sort of meditative exercise for me, but each one to his own. I mean, each one chants or recites whatever is the prayer. But I think some form of thanksgiving on a daily basis helps.
Yeah.
What else? I think maybe wanting to be curious to learn something new every day. It keeps you sort of going. It keeps your mind active. I mean, I like to do a Wordle every morning if I can, and most times I succeed.
Yeah.
Very rarely, but that's a very simplistic sort of thing. But something, it can be, you can learn something new on any topic, whether it is sport, law, arts, science, whatever. Something new, and that curiosity, I think, would help to. And one important thing for me, and I know I'm ribbed about it by my friends a lot, is to have an afternoon nap, if you can have it, wherever you are. I find it rejuvenates you. Yeah. I find it gives you a second wind for the rest of the evening. But again, that's a personal thing. And maybe from a lawyer's preparation point of view, I mean, as I'm talking, it strikes me. Maybe when you get a new brief to read, what I would generally do is just skim through it in the night before going to bed. Just skim through it, not really read it in detail. Just understand what the broad contours of the matter is, and then read it in detail in the morning. And I find it helps a great deal, because the little that you read, or the broad sort of contours of the matter, you subconsciously start thinking about it in the night. And sometimes you come up with answers, and when you start reading it in detail in the morning. So that's something that again, I don't know whether it's a productivity tip or whatever.
No, but that's a great tip.
It's something that has worked for me.
Yes, it's a great tip. Okay, all 5 are nice. We were doing with Justice Patel. He's like, "What? What a productivity tip! Just be productive." We had to edit that. Anyway, 4 books. Books. It need not be law books. It could be whatever you want. That you recommend anyone should read.
It probably, a large part of my reading is sport, and particularly cricket. one of the best I've read, and I would recommend it to anybody, is Rajendra Amarnath's biography of his father, Lala Amarnath. It's a very well-written book.
Okay.
It's a fascinating read. It tells you a lot about cricket in those days, etc. And Lala was a very colorful personality. The other would be Prashant Kidambi's book called the country cricket or country whatever. Again, a fascinating account of the 1911 tour of England, but with a lot of historical background and and also a lot of the society as it existed then. Because cricket in India has been a part of the larger society, and he's done a brilliant job with that book. I would recommend that unhesitatingly to anybody. Non-cricket, I would say, one of the books that has fascinated me, I think it's lying just here in my library, is the book called In God's Name by David Yarrep. It's about Pope John Paul. It's about the papacy, and gives you a background of the papacy and John Paul II, I think. I may be wrong, Pope John Paul II. And again, a fascinating read. It's a gripping read.
Okay.
And maybe I would add to that list a book which I probably read in my college days. But some of what was said in that book has stayed with me right through. I mean, it was a very popular book at one time. How to Stop Worrying and Start Living by Dale Carnegie. Dale Carnegie. I mean, it was a bestseller and stuff like that. So it gives you a little thing of how to face life's problems, kind of thing. And some of what, as I say, some of what I read all those many years ago has stayed with me. And if you'll permit me, one more book, which is my own.
I didn't know that you had
the book that I edited called Willow Tales, The Lighter Side of Indian Cricket. It's a slim little book and done many years ago. But I know some friends, and I remember Mr. Anil Devan, one of our leading lawyers, always telling me that, after a hard day of reading and being focused on the law, if I wanted a little light entertainment, I would pick up your book from my bookshelf and read at random. And it would generally sort of cheer me up. So I like to think that book has had some value.
So what is it? Slim one. What is it about?
It's just anecdotes about Indian
lighter side
from various people.
Okay.
And I merely edited it and put it all together. And I remember among the various people I wrote to asking for these anecdotes was the great Australian Richie Beno. And he didn't send me a piece, but he wrote to me saying, "This is the first time that I know of anybody who wants others to write the book for him." And I mentioned it in my foreword, and I said, I hope he had his cheek firmly in his tongue firmly in his cheek. And I sent him the book, and he sent me a very sweet letter back. So it was quite a interesting.
Okay, so we will put an Amazon link. Is it on Amazon?
I don't think so. It was published many years ago. But it's still around.
Yeah, it's around. Okay, 3 tips for young lawyers or law students.
You're assuming that I'm qualified to give these tips. But I suppose the first one would be the obvious one. Work hard. I mean, there's no substitute for hard work in this profession. And when I say work hard, it doesn't necessarily mean only on your briefs. I mean, assuming it takes time sometimes to get your briefs. Working hard can also mean sitting in the library and reading books, or maybe now the younger generation does it on their computers. But reading law reports, reading articles on the law. A lot of this stuff, when going to court and hearing other advocates argue, senior advocates arguing, it helps a great deal when you're just starting out, or when you're in the early years of your profession. I think one other thing I would say to somebody starting out is, it's all very well to be immersed in the law. We all are. I mean, law is a jealous mistress, as they say. But I think you must have some interest or some passion outside the law. It genuinely helps you in the profession. It can be anything. I mean, it can be In my case, it was sport, cricket, writing on cricket, etc. Sports presentations, doing sports roundup, Himalayan Rally, the Asian Games in 1982.
Wow.
A whole lot of ODIs, test matches, Ranji Trophy matches, a whole lot of stuff like that. But you must have something outside the law which genuinely helps you in. It can be something in science, for example, if you're inclined that way. And, I get a lot of young people, young lawyers, sometimes coming to me and seeking advice on what they consider to be life-changing decisions. Should I be a solicitor or should I start counsel practice? When should I switch? Should I go into an organization set up, as you say, general counsel, and not that starting at that level, but starting more? Or should I risk coming to a court practice? Should I do transactions or should I do litigation? I think the best tip that I can give is that when you are at that stage and making a decision, I think take whatever advice you want to, because ultimately the decision is yours. Take advice of people you trust. But ultimately go by your gut. Go by your intuition. What you intuitively believe is the right thing. And I don't think you can go wrong, because sometimes these youngsters tend to overthink this. And I can understand. We all face that dilemma. But when you overthink something, you don't do what you really want to do. So maybe that's something that one can pass on to a young lawyer.
Yeah, true.
Maybe I don't want this thing to end on a very serious note.
No, we have two more. Two life lessons you've learned.
Oh dear.
In life. All very heavy, like.
Yeah, I know.
So all the last questions are like too heavy. Two life lessons.
I think one is count your blessings. Learn to count your blessings. I think most of us take a lot of the things we have for granted. And we complain about a lot of things. I honestly believe, and maybe I don't live up to it, to that belief every time, but I honestly believe that people positioned as we are have really no right to complain. Considering what we have, a roof over our heads, the ability to have a warm or cold shower whenever you want. I mean, I know I'm talking in terms of a very mundane sort of thing. But it is really, that's one of the things that I think counting your blessings is a great thing. And the other, I would say, is that if you are the complaining type, or if you are someone who objects to something, someone who complains about something, protests about something, I think it's not just enough to complain or protest or object. You must give a solution to that problem. If you find a problem, you must come up with a solution. My solution may be accepted, not accepted, maybe modified, not modified, whatever. But it's not enough to just complain or just protest. Then it is as much your obligation to come up with offer a solution to that problem.
All new life lessons. Okay, finally, the best piece of advice, the one best piece of advice that you've received.
Oh dear. Best piece of advice I ever received.
Yeah.
I think it's, I can't remember who, maybe maybe it was my mother, or I can't remember. But it was always that belief that everything that happens for the best. Once you once that belief is ingrained in you, things go wrong. Very often they do go wrong. And things can go horribly wrong. It worries you. Spend sleepless nights. But when you have this sort of a belief, I think you tend to cope with this thing much better. And I have an illustration which is just a very short one, but the second, if you permit me, two instead of one.
Of course.
Again, just as you say, thinking on your feet. I think some of the best advice was never be envious, particularly in this profession. There will always be somebody better off than you, higher than you. There will always be somebody lower than you, below you. So envy is often destructive. So I don't think one should ever be envious. And as far as the first was concerned, I think, it just comes back to me as I'm talking to you. Years ago, I was a relative junior.
Huh.
I was briefed in a matter before the senior Justice Dhanuka, Ramesh's father. It was one day before the vacation. My attorney was Apul Munim of Bachubai Munim and Company. And it was a corporate fight. We were for one group of shareholders, and obviously the other side was for the other group. And we were desperate to pass a particular resolution at a board meeting or AG. I think it was an AGM. And the other side obviously applied for ad interim. It was the last day before vacation. Huge number of ad interim injunctions and, all this dhamal in court kind of thing. And there was really no time to argue a matter fully, but you presented whatever you had to. It was very important for us to have passed that resolution. And the judge was against us and wouldn't buy the argument that we had. But we got an order which said, all right, pass your resolution, but don't disclose the result. Keep it in a sealed envelope, etc. And we came out of court very disappointed. The client was very disappointed. The attorney was disappointed. I, of course, I couldn't sleep that night kind of thing. A few months later, this order was passed. The next day was the vacation. Vacation passed. We got back into court. A few months later, Atul called me up and he thanked me. And I said, what for? He said, you remember that injunction we got was against us? We were not supposed to. Apparently, some events had happened in the intervening period when we now wanted that the result should not be declared. And the other side was desperate that the result should be declared. But because of that injunction that had been granted, the other side couldn't have those. So Atul was ecstatic. He said, because of their injunction now, we are in a position where we are not going to allow them to disclose the. And I said to myself, how ironic. And I was so overwhelmed. I was so upset. I couldn't. I had a sleepless night. And look how things have panned out. So I think if you have this belief, ultimately things work out in the way in which you want them.
You're right, I think this is a beautiful reminder for us also. Two beautiful reminders. One is what you said, that you never know. Everything happens for the best. Just chill. And the second
you're making me feel more philosophical than I usually am.
Well, I'm sorry. And the second reminder is that there are people who are senior counsels who've done very well, who have sleepless nights.
Oh, yes.
So it's okay, I guess, if we are all.
It was. I had such a instructive. We used to sit on the lunch table with Mr. Iqbal Char and Nikki, and I must have come back once from court with. Maybe the judge had said something, or I had sort of not been able to persuade the judge to my point of view. Must have been a little flustered. And I said, Nikki, I spend sleepless nights, sometimes reliving what has happened in court. Could I have put a point better? Could I have done this? Should I have said this instead of this? It's all an retro analysis kind of thing, up to a point. And you can't get mired in this. And what Mickey told me took my breath away. He said, Freddie, half the world calls me Freddie. Freddie, you are saying this. I still today, and he must have spent over 50 years at the bar, he said, I still today go home in big matters and relive the day of what I have argued in court and wonder whether what the argument put forth by me was the correct argument. And as you say, could I have put it in a better way? Now, if the gentleman who was at the top of the profession could do that, it was a very instructive thing for me. And I suppose we all kind of live through this sort of thing.
And it's okay. It's okay. It's fine. But I had such a wonderful time talking to you. And thank you so much. We were horrendously late today. One of those things that happened that went wrong. Yes.
I must remember to say Mumbai and not Mumbai.
Even I have to edit and say Mumbai. So one of those things that went wrong, but then turned out well, because apart from this recording, there's so much more that I learned about you. So thank you so much, sir, for your time and for all the lessons and anecdotes that you shared. Did you have a good time?
I wish you well in all the endeavors that you are doing for this sort of podcast, which
thank you.
I think help lawyers. I hope they do.
I also hope they do. Did you have a good time?
Yes, sir.
Yes. Relaxed?
Can I say anything else?
Of course. Please.
No, I won't.
I don't edit that, so you can say. So, thank you so much. Thank you. keep watching us and share, subscribe, do all of that. Tell us which other guests you want to listen to next, and we'll try our best to get them. Thank you.